Good Vach, Shavua Tov, a good week to you, my holy sisters and brothers. Great to start the week right, learning on a Saturday night. Let's light up the darkness. Who's in the house? Nancy in North Carolina, Lucy in Minnesota, Shandor in the Bronx, Paul in the Great Northwest, Melissa in Great Neck, Guy in Ohio, Bell in Florida, Bill, not in mid-Missouri, rather in Chicago, Sharon in New Jersey, Joe in the Inland Empire, Aoife in Florida, Ella was saying shalom. Welcome, everybody. Our daf tonight, excuse me, page 107. We're going to pick it up near the bottom of 106b here in Tractate Bava, Kamma, the 21st volume of the Talmud, continuing our discussion of Mishna number 5 in chapter 9. And looking at all these nuances, we started with the robber who stole, and then not only stole, but swore an oath that he didn't steal. And then he regretted that he'd done both things. He seeks to make amends. He has to restore what he stole, add 1/5, bring an offering. If the temple is standing in Jerusalem, a guilt offering, he becomes liable to that. And as we learned in the Mishnah, he has to go to great lengths to make restitution to the person he robbed personally. He has to show up there, even if that person is very far away. Exception, he can give the property to an agent of the court, and at least according to some opinions, an agent appointed in front of witnesses by the robbery victim. He can't appoint his own agent to transport the property. And once we got into that, we've been talking about other situations where somebody steals either by robbery or by thievery. Right? A thief thinks he got away with it and no one knows. A robber thinks he got away with it, though everyone knows. But then there's other kinds of situations where somebody could have the property of another person because he took a loan, because he borrowed an item, because he was a custodian of that item, which the Koran Talmud translates usually as a bailee, whether it's a paid bailee or an unpaid bailee. Could also be a borrower or a renter, or somebody who found a lost item and hasn't been able to return it yet. In all these situations, they could become dishonest and try to keep that which is not theirs, and even swear an oath to such an effect, and then regret it and make amends, etc. So we're continuing this discussion. So the Gemara cites a related ruling. This is a few paragraphs from the bottom of page 106b. So Rabbi Chia bar Abba says that Rabbi Yochanan says, with regard to one who falsely states the claim, with regard to a lost item, that a thief stole it, i.e., he found a lost item, and when the owner requested its return, this one who found it claimed that it had been stolen from him, and it became known that he lied and had taken the item himself. So this guy didn't confess. At least not without first witnesses coming forward and establishing that he had taken it for himself. So now, at least according to this one opinion, he stands now in the place of a thief, and the thief makes a double payment in restitution when he gets caught. So, right, this one found a lost item, and when the owner requested its return, the one who found it claimed it had been stolen from him, and it became known that he lied and had taken the item himself. So he pays the double payment. What is the reason for this? As it is written in the verse concerning the double payment of a thief, quote, for any matter of trespass from an ox, for a donkey, for a sheep, for a garment, or for any lost item about which one shall say, this is it, the claims of both of them shall come before the judges. The one whom the judges convict shall pay double to his neighbor. That's Exodus 22:8. Now, it can be seen from here that double payment applies to a false claim of theft, even with regard to a lost item. So Rabbi Abba bar Memel raised an objection to Rabbi Chia bar Abba from a Baraisa. The verse states, if a man gives his neighbor money or vessels to safeguard, and it was stolen from the house of the man, if the thief shall be found, he shall pay double. right? So you already see how the circumstances are sort of getting multiplied. The simple case: a thief breaks into my house when I'm not there, or when I'm there but I don't see him, and he steals something, and later we find that object on him. Okay, so he has to make restitution and pay the double payment as a penalty. Now we attenuate that a little bit. The object wasn't in my house. I had entrusted it to the care of someone else, a bailee. As we'll see tonight, there's 4 types of bailees: the paid bailee, the unpaid bailee, the borrower, or the renter. So for whichever one of those situations it was, my object was in the care of somebody else, and the thief stole it from him. Now, some bailees are liable if a thief steals it from them, and some are not, right? So off the top of our heads, the paid bailee, the reason you're paying him is because he's guaranteeing that it won't be stolen from him, and if it is stolen from him, he is liable. Okay, so and then we could have the case where the bailee lies and says it was stolen when it wasn't. All right, so let's see where we are. Right, so the verse states, if a man gives his neighbor money or vessels to safeguard, and it was stolen from the house of the man, if the thief shall be found, he shall pay double. That's Exodus 22:6. So the use of the word man in this verse indicates that the giving of a deposit by a minor is nothing, right? So every word counts. Right, so interesting. And I have derived only a case where he gives a deposit when he is a minor, and he lodges the claim concerning it against the bailee when he is still a minor. From where is it derived that the law would be the same in a case where he gives the deposit when he is a minor, and he lodges the claim concerning it against the bailee when he is an adult? Well, the verse states the claims of both of them shall come before the judges, i.e. the claim is valid only when the giving of the deposit and the claim are equal, both done when he is an adult. Why is this? I mean, it might seem inequitable. We're not exploring all the laws right now of relationships and contracts that a minor can enter into, but suffice it to say that a minor can't create legal obligations because he's a minor. Right, so even if he's an orphan, he's going to have some kind of a custodian, like a guardian, some kind of court-appointed guardian that would enter into contracts for him. And creating a bailee relationship would be the nature of that kind of an agreement. So based on the ruling of this baraisa, Rabbi Abba Bar Memel raises his objection. And if it is so that even one who finds a lost item pays the double payment for claiming falsely that it was stolen, indicating that the giving of the item as a deposit by the owner is not an essential condition to render the thief liable for double payment, then the claim of a minor should be like a lost item as well. And one who received a deposit from a minor should be liable for double payment. And Rabbi Chiya bar Abba said to him, with what are we dealing here? We are dealing with a case where the bailee consumed the deposit when the owner was still a minor, so that at the time it was consumed, the owner had no legal standing. Therefore, the bailee is not obligated to pay. As opposed to where the property that this bailee has and now denies having is right there, and you can point to it and say, "But that's my property. What's it doing in your possession?" As opposed to the case that was just spoken where it had been consumed. Now, Rabbi Abba Bar Memel questions this answer. But had the bailee consumed it when the owner was already an adult, what is the law? Indeed, would the law be that the bailee pays? If so, rather than teaching the claim is valid only when the giving of the deposit and the claim are equal, let the baraisa teach the claim is valid only when the consumption of the deposit and the claim are equal, which would be a more precise ruling. So Rabbi Chiya bar Abba said to him, amend the baraisa and teach the claim is valid only when the consumption of the deposit and the claim are equal. Rav Ashi said a different answer to Rabbi Abba Bar Memel's objection. The two cases are not comparable, so an objection to Rabbi Chiya bar Abba's statement concerning a lost item cannot be derived from the case of a minor giving a deposit. You see why a minor giving a deposit is likened to a person who finds a lost item, because the minor can't enter into a contract. So when the minor placed his item in the care of this bailee, it was like the bailee found a lost item that he is obligated to return, but not because a bailee relationship was created. Right, so the two cases are not comparable. So an objection to Rabbi Hiya bar Abba's statement concerning a lost item cannot be derived from the case of a minor giving a deposit, because the lost item came into the possession of the finder by the power of one who is mentally competent, as the one who lost it is presumed to be an adult, though he did not personally give it to the finder. But this deposit given by a minor did not come into the possession by the power of one who is mentally competent, as from a halakhic perspective, a minor is considered not mentally competent, meaning a minor can't enter into legal relationships. Therefore, he has no grounds for a claim. New subject. The Gemara quotes a related ruling, and Rabbi Hiya bar Abba says that Rabbi Yochanan says, with regard to one who falsely states the claim, with regard to a deposit, that a thief stole it, he is not obligated to take an oath, nor to pay double payment until he denies part of the claim and admits part of the claim. And what is the reason for this? As the verse states, about which one shall say, this is it, indicating an admittance of only this part, but no more. So the Gemara notes, and this disagrees with the ruling of Rabbi Hiya bar Yosef, as Rabbi Hiya bar Yosef says, now we're on 107a, a merging of Torah portions is written here. And the law written in this passage is in fact meant to be applied to a different passage. And when it is written, this is it, from which the law of the partial admission is derived, it is written concerning not a deposit, but a loan. And the Gemara asks, and what is different about a loan that the law would apply only there? And the Gemara answers, it is in accordance with the statement of Rabbah. As Rabbah says, for what reason did the Torah say that one who admits to part of the claim must take an oath? And it is because there is a presumption that a person does not exhibit insolence by lying in the presence of his creditor who had done him a favor by lending money to him. Right? Remember, when a Jew lends to another Jew, it can't be at interest, so it always has to be a favor. And this person who denies part of the claim actually wants to deny all of the debt so as to be exempt. And this fact that he does not deny all of it is because a person does not exhibit insolence. I mean, there's so much psychology at work here. They're saying that they have observed over time, right? They're not making this up out of nothing. But they have observed that when people borrow money from another and are not fully honest about how much they borrowed, they don't say, I didn't borrow anything. They say, well, I borrowed 100 dinars. I didn't borrow 1,000 dinars, something like that. And Rabbah continues, and in order not to exhibit insolence, he wants to admit to the creditor with regard to all of the debt, and this fact that he denies owing him part of it is because he reasons, if I admit to him with regard to all of the debt, he will lodge a claim against me with regard to all of it, and right now I do not have the money to pay. I will evade him at least for now until I have money, and then I will pay him all of it. So this rationalization enables one to falsely deny part of a claim. Therefore, the merciful one imposes an oath on him in order to ensure that he will admit to him with regard to all of the debt. I mean, it's so interesting. The law is solid in the sense you borrow, you need to repay. This idea that one who, denies and then is told to swear an oath that it's not true, and then he's not going to swear that kind of an oath, but he might just say, I don't want to swear an oath. I admit I borrowed some, just not as much as you're saying. Oh, well, swear. And now that he's being made to swear, God willing, he'll just say, okay, you're right. I borrowed all of that. I'll pay it back. I just can't pay you now, etc. Now, the law, it is written concerning a loan. If Reuven claims that Shimon owes him money or movable property, and Shimon has the legal ability to absolve himself of any monetary obligation to Reuven by claiming to have purchased or returned the money or property, or by completely denying having taken it in the first place. But in fact, Shimon admits to part of the claim. He is obligated to pay the amount that he admits to owing, and by Torah law, he takes an oath with regard to the rest of the claim, and is exempt from paying the remainder if he actually swears. Now remember, we have this whole idea that where there is no other evidence, right, we don't have a receipt, we don't have a promissory note, we don't have two witnesses to the loan. It's just one person's word against another, but they come to the court. So that's when Reuven can make Shimon take an oath that he doesn't know. If the guy takes the oath, the case is over. He could be lying, right? He could be lying and he could get away with it, but he's not going to get away with it before the heavenly court. And if he takes such an oath and then it's proven that he's a liar, that is going to harm his reputation in a small community very much, right? Where am I? Okay, so the Gemara completes the answer, and it is with regard to a loan that this can be said, as the basis for this explanation is that one will not exhibit insolence before his creditor who did him a favor by lending him money. But with regard to a deposit, we don't have the same psychology. One will certainly exhibit insolence, as the claimant did him no favor. Therefore, there is no reason to say that one who completely denies a claim concerning a deposit is deemed credible any more than one who admitted to part of it, and he is obligated to take an oath in either case. And now we're actually on 107b. 107a was a very short half-daf. So Rami Bar Kamma teaches this baraisa. All four types of bailees require denial of a part of the claim and admittance of a part of the claim in order to be obligated to take an oath when someone claims to have given them an item as a deposit. And these are they: an unpaid bailee, a borrower, a paid bailee, and a renter. Now, the Gemara quotes the source for this statement. Rava said, what is the reasoning of the statement of Rami Bar Kamma? Concerning an unpaid bailee, right? Please hold on to this to me. Please watch this for me. I'm going out of town. Watch my car. I'm not paying you to do it. So you are doing me a favor. You're going to have the lowest responsibility toward me. You have accepted to watch the car, but because you're not getting paid, because you're not really getting any benefit out of this, your responsibility is going to be at the lowest level. So, concerning the unpaid bailee, it is explicitly written with regard to him, quote, this is it, as explained earlier. Concerning a paid bailee, Rami Bar Kamma learns by means of a verbal analogy to the term giving used with regard to a paid bailee from the term giving used with regard to an unpaid bailee. And since the verses about both a paid and an unpaid bailee begin if a man gives his neighbor, Exodus 22:6 and 22:9. So Rava continues, and again, what he's proving is that if the bailee or the borrower or the renter says, well, yeah, I have some of your property, or you deposited some of what you're claiming you deposited with me, that I have, but the rest of your claim is false. You did not deposit 3 cows with me, you deposited 1 cow with me, that kind of thing. So Rava continues, Rami Bar Kamma learns the law concerning a borrower from the verse, and if vechi, a man borrow, from Exodus 22:13. So there is a principle that the conjunction and, represented by the letter vav, right? We say and by adding a vav to the next word, adds to the previous topic. Based on this principle, the laws of a borrower are connected to those of the subject of the previous verse, which is the bailee. So concerning a renter, if Rami Bar Kamma is stating his ruling according to the one who says that a renter is like a paid bailee, so this is the same as a paid bailee, and if he is stating his ruling according to the one who says that a renter is like an unpaid bailee, well, this is the same as an unpaid bailee. Next topic. And Rabbi Achia Bar Yosef says, with regard to an unpaid bailee who falsely states the claim with regard to a deposit that a thief stole it, right? So I ask you to watch my car as a favor to me. I go away. I come back a month later. I go to get my car, and you say, oh, somebody stole your car. And then it turns out that you lied to me, right? So that's an unpaid bailee who falsely claims that a thief stole it. And it is discovered that he lied. He is not liable to pay the double payment unless he misappropriates it, i.e., he uses it for his own needs before taking his oath, right? In other words, he says it's somebody stole it, but has he done anything with it? If he's actually used it, since it was legally in his possession, since I left it with him, right, to watch it for me, please, he didn't do anything. He didn't take it. But once he uses it for his own needs, that's like an act of thievery, which is now, confirmed when he lies and says that a thief stole it. Where am I? Right, he's not liable to pay the double payment unless he misappropriates it, i.e. uses it for his own needs before he takes that false oath. And what is the reason for this? The verse states, if the thief shall not be found, the owner of the house shall approach the judges to determine if he misappropriated his neighbor's goods. Exodus 22:7. And the following verse concludes, the one whom the judges convict shall pay double to his neighbor. So by inference, one can learn that if he misappropriated it, he is liable for double payment, which is the thief's penalty. And that is to say that we are dealing only with a case where he misappropriates it. Rabbi Chia bar Abba said to his students, this is what Rabbi Yochanan says, they taught this law that one who falsely claims that the deposit was stolen is liable for double payment with regard to an animal still standing over its feeding trough, i.e. the bailee is still safeguarding it for its owner. And Rabbi Zera said to Rabbi Chia bar Abba, is he stating his ruling specifically with regard to an animal standing over its feeding trough? But if the bailee misappropriated it before taking an oath, he has acquired it, and an oath is not effective for him at all, not even to cause him to be liable to pay the double payment? Or perhaps he is stating his ruling even with regard to an animal standing over its feeding trough, in addition to an animal that the bailee misappropriated. And Rabbi Chia bar Abba said to him, I did not hear this ruling, so I cannot transmit Rabbi Yochanan's opinion. But I did hear something similar to it. As Rabbi Asi says that Rabbi Yochanan says, with regard to an unpaid bailee who falsely states the claim that the deposit was lost, and he takes an oath to that effect, and then he retracted and falsely states the claim that a thief stole the deposit, and he takes an oath to that effect, and witnesses came and testified that he lied, he is exempt from the double payment for the second claim. And what is the reason? Is it not due to the fact that he already acquired the item with the first false oath, and therefore the second oath is disregarded, which is why he is not liable for double payment for a false claim of theft? So too, one who misappropriates the deposit thereby acquires it and is no longer obligated to take an oath. Remember, when they say acquires it, that can mean a thief never, it's not like he gets away with it. That's not what it means. It means he acquires it so that legally it's now in his possession, and then the consequences can ensue from that. Now, Rabbi Zera said to him, no, there's no proof from there, because one could argue that the reason is not because he acquired the item with the first oath. Rather, since it left the owner's possession with the bailee taking the first oath, he is exempt from taking an additional oath with regard to the same claim. But his oath will be significant even after having misappropriated the item. And it was also stated that Rabbi Avin says that Rabbi Ilya says, that Rabbi Yochanan says, with regard to one who falsely states the claim with regard to a deposit, that it is now lost. And he takes an oath to that effect. And then he retracts and falsely states the claim that the deposit was taken through theft. And he takes an oath to that effect. And then witnesses came and testified that he lied with regard to the claim of theft. He is exempt from the double payment for the second claim, since it left the owner's possession with the bailee taking the first oath. So remember that the unpaid bailee, if he was watching the animal and then he swears that, well, it was lost, wandered off, Okay, and I suppose that an unpaid, I think a paid bailee would be liable, so would a borrower and a renter, but an unpaid bailee is not. So he swears, yeah, it wandered off, sorry. And at that point, he is absolved. And if there's no, witnesses to the contrary, he's off the hook. The case is over. Then he, of his own volition, says, you know what, I lied. What really happened is it was stolen. That's also a lie, right? And so the witnesses can come and contradict the second lie. But with the first lie, the case was over because he swore. Now, it was a false oath. Then he confesses, but he doesn't confess what really happened. He then goes with another lie. That's why we're in this odd gray area. And it was also stated that Rabbi Avin says that, no, I just read that. Okay. All right. Now, the Gemara cites an Amora, right? So the sages of the Mishnaic period are called Etana, singular, Tanaim, plural. The sages of the Talmudic or the Gemara period are known as singular Amora, plural Amorayim. So the Gemara cites an Amora who disputes the ruling of Rabbi Chiya bar Yosef. Rav Sheshes says, with regard to an unpaid bailee who falsely states the claim with regard to a deposit that a thief stole it and is discovered to have lied, once he misappropriated it before he took an oath, he is exempt. And what is the reason for this? Well, this is what the Merciful One is saying, i.e., this is how the verse is to be understood. If the thief shall not be found, the owner of the house shall approach the judges if he has not misappropriated his neighbor's goods, indicating that this verse speaks specifically with regard to a case where he did not misappropriate the deposit. Consequently, if he did misappropriate it, he is exempt from the double payment, not from returning, but from the double payment of a thief. So Rav Nachman said to Rav Sheshes, but aren't 3 oaths administered by the court to any unpaid bailee who claims that the deposit was stolen from him? And the first is an oath that I was not negligent in safeguarding it, thereby enabling it to be stolen. And the second is an oath that I did not misappropriate it. And the third is an oath that it is not in my possession. So you see that the sages, then legislated to cover these loopholes, as it were. And if somebody is being made to swear at all, then he's going to have to swear he was not negligent. It's not still in his possession, and he personally did not misappropriate it. That is not his possession. And what? Is it not? In other words, did they not legislate this so that an oath that I did not misappropriate it is similar to an oath that it is not in my possession in the following manner? Just as with regard to an oath that it is not in my possession, when the matter becomes revealed that it is in his possession, he is liable. So too, with regard to an oath that I did not misappropriate it, when the matter becomes revealed that he did misappropriate it, he should be liable. I'm almost done. Questions or comments, please get them in now. So Rav Sheshes said to him, no, there is no proof from there, because one could say that the law of an oath that I did not misappropriate it is similar to the law of an oath that I was not negligent in safeguarding it in the following manner. Just as with regard to an oath that I was not negligent in safeguarding it, when the matter becomes revealed that he was negligent in safeguarding it, he is exempt from double payment. Negligent is not the same as being a thief. So too, with regard to an oath that I did not misappropriate it, when the matter becomes revealed that he did misappropriate it, he is exempt from double payment. Since the comparison can be made between different pairings of the oaths to suggest opposite conclusions, none of these comparisons are definitive, right? So remember, when a court is going to step in and extract a double payment, that is specifically the law of the thief, and it might be the law of one who had a deposit, maybe all 4 categories, maybe not, but who had a deposit and claims it was stolen, and then it's proven that that was a lie. Now we have these other variations, very nuanced variations, but the nuances matter. And what they're asking is, when does that written Torah obligation to make restitution via a double payment actually kick in, and the sages are not going to willy-nilly extend that obligation. That's why they're being so careful to check all of these cases, as it were. Okay. One question from Joe. When making contracts or agreements, was it common to do so before two witnesses? And then you say, when witnessing the signature of someone on a document today, two witnesses signed to state that, in fact, it was not fraudulently signed. Yes, I mean, especially this was the whole idea of a written contract, which is, we open an app, we agree to a written contract. But it was much more unusual. Right? Most people, in the Jewish world, most people were literate. That was kind of unusual in the ancient world. But even in the Jewish world, not everyone was literate. And access to parchment and quill and, writing up, you would hire a scribe for that. They didn't have the actual job of lawyer, right? But there would be expert rabbis that would help people. So when they would enter into important agreements, certainly, purchase and sale of real property, purchase and sale of an ox, right? Purchase and sale of the produce of a field. They would make a point, but it wasn't always necessarily done in writing. It might have been done in the presence of two witnesses. If anything that was important, certainly. But think about how many interactions we just have with our neighbors, the door-to-door salesman, as it were, where the two witnesses aren't going to be present, right? And, sadly, not everyone in the world is an honest and pious person, and you could interact with unscrupulous people who would take advantage of the system, and then we have to kind of work our way through that. And basically, the Torah would legislate, certain remedies, but it couldn't, no code of law can legislate a remedy for every situation. And there's so much to it. And that's why it's so important that this whole system is within a context of know, right? Read this in Pirkei Avos, know who is above you, and who is at a seeing eye that sees everything and writes everything down, as it were, right? So there's the ledger of your life, the ledger of my life, and only God, has the vision in past, present, and future to understand what everyone has done and how that connects to the actions of everyone else. And we have an absolute faith that God is not only merciful and kind, but just, right? And so, sometimes the earthly court is not going to be able to make it good. There's a limitation of how many situations can be made good by an earthly court. And I think that this reticence to go too far is very important, right? Because courts, in an effort, especially you see this in modern times, that very often legislators and judges, in an effort to produce an equitable outcome according to the facts that they're given to see, the way it appears, they want to do what feels fair. And later, additional facts could come forward and see, it wasn't so obvious what the case was. Or in a particular, that's what we had. I remember when I went to law school, there was this saying, I'm sure all lawyers are familiar with it, and non-lawyers too, that tough cases make bad law, right? So in a particular set of circumstances, this is what we need to do to make it right. But then we establish a precedent or we pass a law to cover that situation. And then there's going to be many other cases where that law or that precedent will produce very unjust results, right? So, this idea of the sages of Israel often acting as judges in litigation before Beis Din, before rabbinic court, to not overreach with the decrees that they pass, with the precedents that they set, and say, well, this the Torah allows us to do, this the rabbinic tradition allows us to do, and beyond that, we can't. And there's a reason to stop, as it were. That's what I've got for us tonight. And with God's help, we'll be together again tomorrow, Sunday, at the regular time, 6 p.m. Pacific. Have a good night and a great week. Shavua Tov, good vach.